on all of those who are attending us from the four corners of the world. It gives you to today's panel discussion on Sole Arbitrator Appointments being organized by the Center for Arbitration and Research at Maharashtra National Law University, Mumbai. My name is Yashraj, Samant, your moderator for the day, so please bear with me. It gives me also immense pleasure to introduce and welcome all our panelists, chaired by Honorable Mr. Justice S.C. Gupte, Judge of the Bombay High Court. Let me first introduce Ms. Neeti Sachdeva, who will be giving opening remarks for the day, and also introduce Justice Gupte later on. Ms. Sachdeva is the Secretary General and Registrar at the Mumbai Center for International Arbitration, a leading arbitral institution in India. Neeti has worked extensively in the field of arbitration, both in private practice and as an administrator. She is a regular at the conferences and also as an arbitrator, and has been ever so supportive of the Center for Arbitration and Research at our university. Over to you, Ms. Sachdeva. You're on mute, ma'am. I think you'll have to unmute.
Yes. Thank you, Yashraj. Good afternoon, Justice Gupte. Good afternoon, dear fellow panelists, and good afternoon to everyone joining us today. Many thanks to Center for Arbitration and Research, MNLU, Mr. Chirag Balyan and Yashraj for inviting me to be a part of this webinar on an important topic, Sole Arbitrator Appointments. An arbitration is as good as an arbitrator. In this backdrop, the topic of appointing sole arbitrator becomes very crucial and important. What are the advantages of an arbitration? One of the biggest advantages of arbitration is this, that the parties can choose their own adjudicator within the walls of independence and impartiality. They can specify the qualification, experience, expertise that they require out of their adjudicator, unlike in a litigation. And hence, the question becomes very important that whether the party should agree for one arbitrator or should agree for three arbitrators. The Unanswered model law of arbitration and the Unanswered arbitration rules both provide for a default position to be three arbitrators. That is, if the arbitration agreement does not specify the number of arbitrators, then by default, the three arbitrators shall be appointed. However, arbitral institutions like ICC, LCIA, SIAC, MCIA all provide that unless otherwise agreed by the parties, a sole arbitrator shall be appointed. Hence, why is it an important decision and when it should be taken is the two considerations that we should look at today. Why is it an important decision whether to have sole arbitrator or to have three-member tribunal? I could probably talk about two major advantages. One is speed and second, economy, or as we all call about time and cost. Why speed? If you have one arbitrator, we all know that one of the biggest troubles in, if you've had an experience of sitting as an arbitrator or as a counsel, one of the biggest troubles that you have is to match the diaries of the three arbitrators along with the two counsels. So if you reduce it to one arbitrator, then the chances of getting a quicker hearing and to get your arbitration done quickly are much more advantageous to have in that sense a sole arbitrator. Why economy? Because you pay the fees and expense of only one arbitrator. It is also argued that proceedings get completed more quickly because no deliberations take place within the arbitral tribunal. But whether this is an advantage or not could be a topic of discussion itself. The advantage of sole arbitrator is only if the parties can unanimously appoint or agree on the appointment. And why do I say so? The premise on which we started to say that why an arbitration is advantageous is because parties can actually decide onto their own adjudicator. If in a sole arbitrator situation, parties cannot agree unanimously, then ultimately the choice is left either to an arbitral institution or to a court. And some of the authors have gone to the extent of saying that in such a situation then, either the institution or court literally imposes upon their choice. So it may be a tricky situation that all the reason for having an arbitration may be lost in terms of appointing the arbitrator itself. The second difficult situation arises where you have two parties, one from a civil law jurisdiction and another from a common law jurisdiction. And this is very common, especially in an Indian context as well. In such a situation, there may always be a question that if a sole arbitrator is being appointed, then he or she is from which jurisdiction? Authors have also opined that there is a greater risk of rogue decisions if there are lack of deliberations in itself. Hence, it is also important that this decision be taken well in advance while at the drafting of the arbitration agreement itself, rather than leaving it to the institution or to decide once dispute has arisen. And why do I say so? Firstly, there's going to be clarity at the time when the arbitration dispute is starting itself. And secondly, like I said, it will depend as to which institution are you adopting. If you're adopting any of the LCIA, ICC, SIAC, MCIA, then you will be saddled with, of course, having a sole arbitrator. But if you were under the UNCITRAL arbitration rules, then you will have 3 arbitrators appointed. With these thoughts, I wish the webinar all the success. I wish participants good luck and hope that after hearing the experienced speakers, they would be able to identify the parameters to be considered for deciding a sole or 3-member tribunal and adopt those while drafting the arbitration clauses itself. Let me now don on my other hat now, which is that I have the privilege and honor of introducing the chair for today's discussions, Justice S.C. Gupte, Judge, Bombay High Court. We are well aware that role of courts has been very critical as being supportive of arbitration, and in Indian context, they play a vital role in the appointment of arbitrators too. Bombay High Court has been very supportive of arbitration with some of its progressive judgments. In more than one matter, Bombay High Court has also exercised its power to nominate MCIA to appoint an arbitrator in a matter referred to the court, thereby adopting a hands-off approach and instilling confidence in the process of institution arbitration. Justice Gupte has completed his education from Chembur High School and graduated from Rua College, Mumbai. He did his law from Mumbai as well from New Law College and was enrolled as an advocate on the rolls of Bar Council of Maharashtra and Goa. He extensively practiced on both original and appellate side in the Bombay High Court in civil, constitutional, company, arbitration, and indirect taxation matters. He regularly appeared in the Supreme Court, various high courts, tribunals, and district courts before he decided to move on and take on the gown and be the judge of the Bombay High Court. Without much ado, let me welcome Justice Gupte to this webinar. Many thanks, sir, for joining us. And now over to you for your address to the participants. Thank you once again.
Thank you, Ms. Sachdeva, for this kind introduction. And a very good afternoon to all participants and viewers from and greetings of the day to all. This webinar, which involves one of the most important subjects in arbitration, namely selection and appointment of an arbitral tribunal. It is in fact central to the very arbitral process. As Neeti opened her arbitration is only as the arbitrator. After all, one major reason why parties prefer an arbitral tribunal over ordinary courts of law is they can select judges of their own choice and confidence. But how should such tribunal be constituted? Particularly whether it should consist of a sole arbitrator or any other number of arbitrators. And legal parameters of such selection of arbitrators. These are the areas which I believe we are going to webinar. Now, Indian arbitration law, particularly Section 2D of the Arbitration and Conciliation Act, and also Section 2A of the UNCITRAL draft model law on which it is based, provide that arbitral tribunal means a sole arbitrator or a panel of arbitrators. The selection of a sole arbitrator and panel is essentially and in the first place a matter of agreement between the parties. This is based on the fundamental idea of party autonomy in arbitration. There are, however, important issues concerning such party autonomy and selection of arbitrators based thereon. The first and foremost of these issues of what is under this clause, only one party can choose either the method of resolving arbitral disputes, bilateral disputes, or worse still, to what extent is such a clause enforceable? Some jurisdictions, of course, do accept such a clause, however, enforceable. And even in India, till as late as the amendment of the Arbitration Act 1996 in 2015, even our courts accepted enforceability of such a clause, presumably in the name of party autonomy. Well, the legislature then had to intervene by way of the 2015 amendment, which firmly introduced the requirement of neutrality in the appointment of arbitrator. Even where the choice of an arbitrator is governed by an agreement, by an agreed arbitration clause. The amendment brought in the 7th schedule in the 1996 Act, setting out different categories of ineligibility for appointment as an arbitrator, and added a new subsection to section 12, which provides for grounds of challenge to an arbitrator, namely subsection 5. Subsection 5 provides that notwithstanding any agreement to the contrary, any person whose relationship either with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule, he shall be ineligible to be appointed as an arbitrator. This, of course, that is to say, it is subject to any subsequent agreement between the parties. The applicable consultants, advisors, persons having past, present managers, lawyers, who are already excluded from being appointed as arbitrators in any reference involving the party or the counsel. The Supreme Court carried this provision to its logical conclusion in its, that is the cases of Delhi Metro Rail Corporation and also the well-known case of Perkins Eastern Markets. The court held that any party, official or authority having any interest in the dispute or in its outcome was ineligible to appoint an arbitrator. Well, with that, the Supreme Court appeared to have dealt a final nail, so to say, on this unilateral appointment of us. Though we find that have been indeed some inroads which have been made, and there is a serious controversy as to whether the Perkins law is diluted by the Supreme Court. I'm sure this would be debated at some length by panelists today. Well, it is important to remember that party autonomy is not the sole guiding principle of the arbitral regime. There is also an equally important principle of impartiality and neutrality of the arbitral tribunal. And this latter principle cannot be sacrificed for the sake of the former. Different jurisdictions and arbitration institutions have made different provisions to ensure coexistence of these two principles. In England, for example, where parties are free to agree on the number of arbitrators, the appointment of such arbitrators, and whether a chairman or umpire is to be appointed, tribunal, etc. The parties have also been empowered to challenge the appointment of an arbitrator if that arbitrator does not act fairly or impartially in the treatment of the parties. Under LCIA rules, you have prior to the appointment, the prospective arbitrator candidate has to sign a declaration that no circumstances known to him or her are likely to give rise to any justifiable doubts as to his or her impartiality or independence other than those disclosed by him or her. LCIA then at the bidding of either party considers whether to sustain or reject the appointment. Even in US, most arbitral rules of institutions require neutrality of arbitrators, thereby imposing a corresponding duty on the arbitrators to investigate conflicts of interest and disclose facts likely to affect their judgment. And upon such disclosure, parties can object to the appointment, whereupon the concerned arbitration institution determines whether the named arbitrator should be disqualified. In India, as we have already noted, we now have the 7th schedule listing various circumstances of ineligibility. And whereas a party is free to challenge an arbitrator on the ground of bias or lack of neutrality before the tribunal itself, it cannot go to a court or arbitral institution entrusted with appointment procedure, except after conclusion of the reference when it challenges the award. But there is one important rider, and that comes from a recent Supreme Court judgment, where the court has made a distinction between grounds of ineligibility under the 7th schedule and grounds giving rise to justifiable doubts as to the arbitrator's independence or impartiality mentioned in the 5th schedule. In the case of the 7th schedule grounds, a challenge may be possible at the reference stage itself under section 14.2, though not under 11.6 or any other provision. Under 14.2, which talks about termination of mandate, a challenge may be available at the reference stage, but not in the case of any independent grounds under Schedule 5. As you know, about 19 grounds of Schedule 5, the first 19 grounds of Schedule 5 and Schedule 7 are common. Then Schedule 5 has its own grounds. So if those grounds exist, the challenge may have to be taken only before the tribunal, and then I'm sure we'll be having a lot on this, both the international Indian perspective. We may also have an overview of the approaches of different jurisdictions and institutions on the number of arbitrators, whether a sole arbitrator or a panel, the timing of their selection, their professional qualifications, etc. In India, the law insists on an odd number of arbitrators, though the default option is a sole arbitrator. The selection either is in the arbitration agreement itself, or in the manner provided in the agreement, or in default of failure of such agreement by the court. That is to say, either the Supreme Court or High Court, as the case may be, or any person or institution designated by the court. Well, there is an interesting line of case law on how should the court or institution appoint of a specific agreement prescribing a particular number of arbitrators or panel of arbitrators or the manner of their selection. The case law revolves around the words necessary measure used in section 11, to describe the action to be taken by the court or the institution or the person when appointment procedure under the agreement fails. Is the court or appointing authority then bound to follow the mandate of the agreement, the arbitration agreement, or should it act independently of that agreement? And there is a line of authorities which says that necessary measure implies nothing but appointment as per agreement. Then there is the other line which says, no, it can be independent of the agreement. This line insists that the court, after all, is approached directly for appointment and not merely for ordering the party or the appointing authority to do so. And then there is this third line, which is a sort of a halfway house, which provides that though by far there should be a deference to the party autonomy, yet the court may, in the interest of justice, make an exception in an appropriate case by creatively bypassing the agreement. This latter view appears to be the currently favored view. This will throw a greater light on these matters in the course of the webinar. With this introductory remarks, I would like to throw open the field to our panelists and their interlocutors. Thank you.
Thank you so much, sir. In fact, it is such a pleasure and a privilege to hear sir speak and give us and impart his words of wisdom with us. So flawlessly, he's been able to literally dissect the whole Arbitration Act, including the new amendments, that it's a pleasure for all of us and a learning for young lawyers such as myself. Sir, you have literally set the pace for the whole of the webinar, giving us lots of food for thought and lots to discuss about. The only thing that we might be short upon today would be time, but definitely not content. With that, it gives me immense pleasure to introduce our panel for today, who will be leading the discussion from the front. Starting with Professor Steve Naw. Professor Steve Naw is an international arbitrator, an academic, and an arbitration specialist, and the current president of the Beihai Asia International Arbitration Center based in Singapore. He has been focusing on ASEAN economies with specialization with Indonesia, and he has been an advisor to public and private entities, not only on post-dispute matters, but business negotiation, mediation, and dispute management. Having had an extensive experience in dealing with parties from all over the world, bringing strong cross-cultural proficiency not only to international dispute resolution processes, but also business strategizing. In the course of his work, he has developed vast experience and understanding in dealing with the private sector, listed companies, and the public sector. In addition to international commercial arbitration, he has been consulted on potential investor-state arbitrations, evaluating cases against and for the state party. We welcome you, Professor Naw. Joining him on the panel is Mr. Shashank Garg. For anyone who knows arbitration or who's interested in arbitration, Mr. Garg needs no introduction whatsoever, but I shall do my bit. Mr. Garg is the current partner and head of the Delhi office for Advani & Co. And he's one of the most well-known names in the global arbitration space, specializing in international commercial arbitration, institution and domestic ad hoc arbitration, mediation, civil and commercial litigation, and regulatory disputes. He enjoys a great standing in the industry and is one of India's most prominent professionals pioneering the advancement of arbitration in India. He was recently honored as a rising 40 under 40 by the Legal Era. He's currently the convener of the Indian Arbitration Forum, and he's also a member of the Chartered Institute of Arbitrators and was one of the rapporteur appointed by the Indian Bar Association recently for its subcommittee. We welcome you, sir. And joining them on the panel will be Mr. Kevin Nash. He's currently the Deputy Registrar and the Center Director for Singapore International Arbitration Center based in Singapore. As Deputy Registrar and the Center Director of the SIAC, Kevin assists with the administration of all cases filed with SIAC and the supervision of SIAC's multinational secretariat. Since joining SIAC in 2012, Kevin has overseen the administration of thousands of international cases under all versions of the SIAC rules, a unique feat in itself, and the UNCITRAL arbitration rules, among others. And he has significant experience in SIAC cases involving expedited procedure, emergency arbitration, and the early dismissal of claims and defenses. He has closely worked on the revisions of SIAC rules 2013-16 and the investment arbitration rules of 2017, and will lead the SIAC Secretariat Subcommittee on the drafting of the 7th edition of the SIAC rules with an expected release in the 3rd quarter of 2021. A BA from Mount Allison University and a JD from Osgoode Hall Law School, Kevin has worked at one of Canada's prominent Seven Sisters law firms and then went on to study LLM and International Commercial Arbitration at Stockholm University. He's qualified as a barrister and solicitor with the Law Society of Upper Canada. Welcome, Kevin. With that, I would like to throw open the floor with just some questions for the entire panel to get some opening views running. In very brief to all the panelists, what has been your experiences and what's the good part you found in your capacities as counsel, as arbitrator, and from the institutional perspective while dealing with single arbitrators vis-a-vis a tribunal of say 3? Let's start with Professor No. I think you'll have to unmute, Professor.
Yes, thank you so much for the kind introduction. I think to set the backdrop of today's discussion, I thought I would like to first deal with this topic from 3 perspectives first. The first perspective in terms of the explicit choice of the parties as to the number of arbitrators. The second would be the parties not making the choices but submitting to procedural rules. And thirdly would be parties not having any choices due to the procedural rules. So allow me to very quickly explain 3 of these scenarios. In the first scenario here, the parties state the number of arbitrators in the arbitration clause. So they are lucid about their intentions as to the number of arbitrators. They know what they need and what they want. For instance, a high value or high risk transaction may naturally or lead to substantially higher value disputes arising in the future. And for instance, if we look at the Indus Water Kishaganga arbitration, the arbitration agreement actually provides for the appointment of 7 arbitrators, of which each of the parties shall appoint 2 arbitrators, and the remaining 3 arbitrators will also include highly qualified engineers. So on this point, I think it is also very important to note that when the tribunal is more than 1 arbitrator, we are talking about at least the talent diversity in terms of the choice of arbitrators. As for the second scenario, this sometimes could be by design or accident, whereby parties did not state the number of arbitrators. Sometimes the parties may be undecided, hence leaving it open. Interestingly, for example, the standard ICC arbitration clause states that dispute arising shall be settled under its rules by 1 or more arbitrators appointed in accordance with its set rules. So 1 or more. Of course, the drafters could have agreed at the outset, the parties could have agreed to the number of arbitrators by fixing it. Nevertheless, I think we will discuss about this more. Sometimes also by accident, so to speak, possibly because of another midnight clause, the parties might have overlooked the idea or the importance of fixing the number of arbitrators, or simply might just prefer to leave it open as it is. But nevertheless, on the point of the number alone, the default number, the absence of stipulating it shouldn't be considered something fatal, because most arbitral procedures provide for the default number. And the default number is sometimes also, or rather most of the time, influenced by the policy of considering cost saving, thus sole arbitrator, or the fullest extent of representation, in therefore 3 arbitrators. For example, the Singapore International Arbitration Act, the default position is a sole arbitrator. The English Arbitration Act also sole arbitrator. The ICC rules, sole arbitrator unless the court considers the dispute warrant 3 arbitrators. The UNCITRAL rules 3 arbitrators. And finally, in the third scenario, the parties sometimes may not have a choice because predominantly in institutional rules, expedited procedures or other such measures may result in the parties, despite prior agreement on the number of arbitrators, find their intention overridden by the authority designated in the rules. So take, for instance, expedited rules of institutions tend to designate sole arbitrator in the interest of speed and simplifying the proceedings when the amount of dispute falls below a certain prescribed threshold. This could potentially lead to controversy whereby a party, typically the losing party, may later raise the argument that there has been a breach of due process as the parties' explicit choice in the number of arbitrators have been overridden. So in a nutshell, I would just stop at that and let other panelists share their views.
Thank you so much, Professor. I think now that we have already set some of the basics, right, that what are the different cases in which the appointment of sole arbitrator, etc., is envisioned through the party's choice. Just wanted to hear from Mr. Garg, what has been his experience, rather, especially in the categories where parties, maybe due to a lack of understanding or lack of professional guidance, if I may, have been unable to specify the number and then resort to a sole arbitrator later.
Yes. So thank you, Yashraj. First of all, for inviting me to speak along with Honorable Justice Gupte, Kevin, and Steve. think the topic is very, very critical given the fact that the only possibility after an award comes is under Section 34 to set it aside. And the grounds of Section 34 are very, very narrow. Therefore, it becomes very, very important and critical for a party to choose its arbitrator very carefully. Now, having said so, it is often seen that parties just use a template agreement and do not pay attention while drafting an arbitration clause. That is why a lot of institutions, again and again, right from SIAC to ICC, MCIA, have been conducting conferences and seminars in India, trying to explain it to parties that how important it is to put a proper clause in your agreement, a dispute resolution clause in the agreement. Now, taking a situation where there is no number specified, however, there is an arbitration clause, the Arbitration Act doesn't provide for any default mechanism. Unlike most institution rules, if you look at SIAC, ICC rules, it would say if there is no number specified, by default, it would be a sole arbitrator. And also, as Steve mentioned about a lot of expedited rules in ICC, in SIAC, even the fast track procedure, which is provided under the Arbitration Act, that provides for a sole arbitrator by default. So not choosing the number of arbitrators can literally lead in a domestic setup in India that it would be a sole arbitrator which will be appointed by the High Court, the concerned High Court. I have not seen, unless both the parties come before the judge appointing the arbitrator in a Section 11 jurisdiction, ask for the judge to appoint a 3-member tribunal for that to happen. So in my experience, if you have not provided the number of arbitrators and if you get into a dispute, the clause is not clear, and if you have to resort to Section 11 jurisdiction, the High Court in most cases by default would appoint a sole arbitrator. So if a number of arbitrators is a concern, then parties must take care of that, because what I feel is that why we require more than one arbitrator is often to increase the objectivity in the decision-making process. However, there are various, disadvantages or cliches attached to number of arbitrators. I mean, when we have plural arbitrators, in words of famous Professor Alan Redfern, he says party appointing an arbitrator expects maximum disposition towards that party with the minimum appearance of bias. So ultimately what happens is that there are 2 arbitrators appointed by parties. Parties expect them to have disposition towards them. And ultimately it boils down to the presiding arbitrator. So the question that comes to our mind is then why do we even go for multiple arbitrators if it is actually the presiding arbitrator who's going to take a final call? So I think these are some of the interesting issues surrounding the need to make sure the number of arbitrators are as per what is expected from a dispute at hand.
Thank you so much, Mr. Garg. Very, very pertinent point, which Professor Redfern had pointed out, that parties expect something from the arbitrator, which leads me to a question for Kevin. Kevin, from the institution's perspective, then how do you identify what is that you ensure as an institution while making sure that sole arbitrators are appointed? What are your checklists that you make sure from the institution's point of view? And how do you balance that against parties' belief in the very essence of party autonomy for arbitration?
Sure. Thank you very much to MNLU. I very much appreciated to be able to hear Justice Gupte. You might have seen me scribbling notes during your intervention, so thank you very much for that. I just want to touch on a few of the points that the other panelists have discussed on the choice between a sole arbitrator and a 3-member tribunal. And to a certain degree, this actually turns on what is the expectation of a party-nominated arbitrator. So the question is this supposed to be an advocate for the party, an adjudicator, or somewhere in between? The distinction that I find helpful and really exemplifies the philosophy at SIC, a party-nominated arbitrator is selected perhaps because of their openness to hearing a certain position of the parties, because of their sector experience, because of the other soft factors. But once the arbitrators are appointed, there is no special duty from a party-nominated arbitrator to that arbitrator. And I think that that can be a helpful dividing line. And the real trick from a practical standpoint when you're drafting arbitration clauses is, if you think about it at the transaction stage, is the dispute may arise 3 or 4 years from the transaction. So how do you know if you need a sole arbitrator or a 3-member tribunal? It could be a very big deal, but the dispute might be 50,000, say USD, or 5 billion USD. How do you deal with that at the drafting stage? We were discussing situations where the arbitration clause is silent. So if the number of arbitrators are not specified, it could be a default sole arbitrator, or the institution, under most sets of institutional rules, could decide that the circumstances warrant the appointment of a 3-member tribunal. It can also go the other direction. 3-member tribunals specified in the clause, most institutional rules, or quite a few, will provide under the expedited procedure that a sole arbitrator may be appointed. So this idea and the concept of a sole arbitrator versus three members is critically important. We will sometimes see very small value disputes, say 50,000, maybe even 5,000, where a 3-member tribunal has been selected. So obviously the time and cost that Neeti was referring to might not be best done by a 3-member tribunal. In that case, a party may want to apply for the expedited procedure, get that sole arbitrator on board. When we're appointing arbitrators, if you look at it from an institutional standpoint, and we appoint thousands of arbitrators, there's really, I guess, 4 or 5 situations where the institution is called upon to appoint the arbitrator. It's always best if the parties can agree, but sometimes the parties won't be able to agree. The circumstances of the clause provides that the institution is going to make the appointment. So the first is the appointment of an emergency arbitrator. You could have the appointment of a sole arbitrator. In the 3-member context, if you had a non-participating party, we might appoint on behalf of that non-participating party. The default under the SIC rules, and this is quite important because every institutional rules is a bit different in this regard. Default SIC appoints the 3rd and presiding arbitrator. So under the Singapore Act, parties make that selection. Sometimes it's co-arbitrators. Say under UNCITRAL, default for us is that the institution appoints the presiding arbitrator. Then you have the DUTCO multi-party situation with multiple parties if both sides can't come to a joint nomination. Then we're going to appoint all 3. And so when you look at the circumstances that we look at when we're appointing arbitrators, it's going to be a bit different depending on a 3-member or sole arbitrator. So let's just stay with the sole arbitrator. You're going to be looking at that sole arbitrator's experience in the sector of the dispute. What's the governing law? Is it common law or civil law? We get a lot of cases governed by Indian law, sometimes say with 2 Indian parties. Ideally, you want to have someone experienced in that governing law. Where's the seat of arbitration, the lex arbitri? Does that arbitrator have experience in the seat of arbitration? What is the sum in dispute? Do we want to be appointing a very senior arbitrator on a high value complex dispute, or can we appoint someone, a precocious younger arbitrator? We're going to look at the nationality of the party. So SIC has no express rules on the nationality of the parties, but if you had an Indian claimant against a Singaporean respondent, you can be very sure when we're appointing a sole arbitrator, that sole arbitrator won't be a national of either India or Singapore. Increasingly, we're looking at diversity in our appointments. So we're looking at gender diversity, generational diversity, geographic diversity, both visible and non-visible elements of diversity, and the intersectionality of those qualities. I think right now in the time of COVID-19 as well, you have to look at an arbitrator's experience and an ability to conduct a hearing virtually. So you might have a virtual hearing where you have counsel, witnesses scattered all around the globe. So does that arbitrator have experience in virtual hearings? The overall tenor of our appointment process is we're looking to appoint the best in the world, anywhere in the world. And you have to look at the parties. So the parties have not been able to agree on a sole arbitrator. So the agreement is always the best situation. You want to appoint a sole arbitrator that is lily white, independent and impartial, and is going to be an arbitrator that makes sense for both sides. Because when you appoint the right arbitrator, the arbitration process moves much easier.
Yashraj, can I ask a follow-up question to Kevin?
Please, sir.
That's fine. Kevin, you mentioned about arbitrators' experience in holding and conducting virtual hearings, and that has become a critical aspect now. It's also an increasingly critical aspect when we appoint arbitrators in the domestic regime, and therefore I want to seek your views. If an arbitrator appointed by SIAC, maybe pre-COVID or during COVID, is unable to perform its functions due to his inability or his inexperience or his lack of technological know-how, would that be a ground for challenge? Would that be a ground that SIAC would consider favorably deciding a challenge? Can a party challenge an arbitrator on the aspect of arbitrator failing to proceed with virtual hearings?
That's interesting. I feel like, Shashank, every time we talk, we're only talking about the most difficult questions. So my view, my interpretation of the SIC rules is that's not a ground for challenge per se, because it doesn't go to independence or impartiality. But if you look at Rule 17 of the SIC rules, that an arbitrator can be removed, importantly by the president on his own volition for a failure to conduct the arbitration with expedience, or from a de facto inability to perform. So I think it would be quite difficult for an arbitrator to be removed just for effectively a lack of technological know-how. I believe the economies are opening up, so some are going by way of virtual hearings, some are waiting until it can be back in person, and then that's the advantage of administered arbitration. You have the institution there to assist and help guide both the tribunal and the parties to be able to take care of this virtual hearing.
Right. Thanks.
Thank you, Kevin, and thank you, Mr. Garg, for that.
May I just say, how about using the provision of something like what we have in India under 14, section 14 of the arbitration for termination of mandate? It has two elements. If either the arbitrator is de jure unable to perform, or de facto unable to perform within a reasonable dispatch. So, of course, the question raised by Mr. Garg, possibly from the.
So your audio is cracking, sir.
So I think towards the end, the question, the audio is connected.
Last line we could not hear, sir.
No, what I was, what I was suggesting is that in Indian context,
Yes,
we could use the provision of section 14, which has two elements: de facto inability to perform as an arbitrator in a reasonable dispatch, or de jure is able to perform so that the arbitrator can brought to an end, within a reasonable time frame that would reflect on his de facto ability to perform as an arbitrator. That is what.
Sir, the difficulty in that is that no arbitrator would explicitly say that I will not be able to perform. It is only through procedural orders one would realize that the arbitrator is not comfortable with technology. And I'm not sure about Bombay High Court, sir, but I think our high courts will be very liberal with these issues and may not really come to the aid of a party challenging under section 14. But yes, I get your point that that is a possible way.
Well, Shashank, to add on to your point, the procedural rules is just one part of it, isn't it? Because failure or impossibility of the arbitrator to act, that is usually a provision enshrined in most arbitration laws. Since we accept that arbitration is not delocalized, it cannot be delocalized. And so arbitration rules, what they apply, the parties, it doesn't mean that it is the end of the road. Should the parties encounter an arbitrator who is completely incompetent, due to circumstances such as now with the use of technology and not being able to respond or be responsive enough, I think that is something worth considering, isn't it?
Yes.
Yes, absolutely. In fact, the point which just leads me to something, that there are certain other factors which definitely are involved apart from these while making that choice by the parties, especially. Some of these, I believe, and Professor Noor would probably like to shed some light upon it. Asia being particularly an area with a lot of MSMEs or medium, small and micro enterprises, they have a very target area or business transactions of a smaller quantity compared to the larger enterprise or multinational corporations. Is that a determining factor while parties, especially in a commercial arbitration, make sure that there is a sole arbitrator in place instead of a tribunal of three?
Quite frankly, I think situation varies, but from my own experiences, this is often like putting the cart before the horse. And it is always after everything has been said and done that when the parties have dispute and they look at their arbitration agreement and they realize that it calls for a tribunal of 3 arbitrators, and the parties will start complaining, saying that even the nature of our business, the underlying transaction is just worth a couple $100,000. Why should we agree to 3 arbitrators, right? It is always like hindsight is always, if we look back, it is always a perfect scenario. But when we encounter it, how do we deal with it? But there are also situations whereby I've seen contracts of relatively high value or large value calls for only a sole arbitrator, because the parties, some of these arbitration agreements have been drafted by even experienced lawyers and counsels, were of the view that arbitration is somewhat, in quote and unquote, evil. It's too expensive. Institutions are making tons of money. So let's limit our exposure. Why do we spend money to recover money? Let's just agree on a sole arbitrator. Then when a dispute has arisen, then they realize that the situation is not, the reality is far from what they envisaged it to be. Then by then it will be a little bit too late, although thankfully some arbitral institutions have procedures that allow the variation of a sole arbitrator to a tribunal of 3 arbitrators when the disputes warrant such, due to complexity and the value of disputes. So coming back to your question in summary or in short, I think this is a very tricky situation, because at the outset, not only that we are talking about people who drafted arbitration agreements or parties who sign on the contract knowing what they are signing into, because quite frankly, they couldn't be too concerned. They are not too concerned about the arbitration clause. They are more concerned about their business relationship, the underlying commercial contract. And so that is why we have situations like what we call midnight clause or pathological clause. So again, in short, it is tricky in that sense that parties don't always know what they want. And so therefore it's not always that question or the opportunity for them to consider whether they had the opportunity to look at their contracts and consult their counsels, the corporate counsels who drafted the agreements for them, to whether to opt for sole arbitrator or 3 arbitrator. It is always something that only when they need to use it, then they will realize it. And by that time, it might be too late.
Right. That's quite a point, Professor, actually. Just one question I had for Kevin right now, particularly when it comes to SIAC's discretion in appointing a sole arbitrator, specifically under your expedited procedure. Now, that is something, again, which usually deals with a set threshold of disputes for a set amount involved. What is usually the procedure there, and what are the indices that you take care or do you account for during your process?
Yeah, so there's most sets of institutional rules have now incorporated this expedited procedure. And I think that to sort of frame the discussion, there's 3 constructions. So you have separate set of rules. So Kuala Lumpur, Stockholm, separate set of rules for expedited procedure. SIC, MCIA, I think, application within the main body, BHA as well, main body of the rules. And then there's also automatic application, like with ICC. So if it's under 2 million USD, it automatically flows through the expedited procedure channel. So we have 3 limbs under which you can apply for the expedited procedure based on the amount in dispute under 6 million Singapore dollars on the basis of party agreement or in cases of exceptional urgency. Most of the action, most of the applications, and we've had more than 500 applications, are interestingly contested. So it'll be based on that first limb that it's under 6 million Singapore dollars. So you have to, when you're considering whether or not to grant the expedited procedure, you're looking at the complexity of the dispute. Is there going to be a jurisdictional phase? Is it bifurcated, trifurcated? Can you get a sense of what the actual value in dispute? Is it quantifiable at this stage? Is it just declaratory relief? Is there even a quantum that applies? You're looking at all of these factors to decide, is this appropriate for the expedited procedure? That's the first stage. And if it is, should it go before a sole arbitrator? The advantage, and when we're talking about the number of arbitrators, the advantage of expedited procedure, particularly within the main body of the rules, is that then if you're drafting a suite of contracts, you can have a 3-member tribunal as a matter of course. So we're not sure if this is going to be a very high value complex dispute. If it is, we have a 3-member tribunal in the clause. If it is a smaller value dispute, a little bit more simple, then we can apply for the expedited procedure, get it before a sole arbitrator and get that time and cost savings. Of course, it's not that simple. There are conflicting decisions on this. There's 2 Singapore decisions that say, yes, the president does have the discretion to appoint a sole arbitrator, even when the arbitration clause provides contrary terms. And then there's a decision by the Shanghai Intermediate Court that at least in that case, to give more effect to the party autonomy and the express language of the rules. So I think that it's almost like, it's like the first day of law school when you have a professor that's telling you how he argues a case, and he says that what he always does is, I say, this is a very simple case. And that is often how these applications go. You have the moving party that says, this is a very simple case. It's perfectly appropriate for the expedited procedure. That's going to require no witnesses of fact, likely can be done on the documents. And you might have the opposing party that says, no, 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 this is a very complicated case. And so the institution's job is to weigh those considerations relatively early in the proceedings and decide whether it should go before the expedited procedure and whether it should be a sole arbitrator or a 3-member tribunal.
Right. That's very informative, Kevin. Thank you so much. Follow-up question to Mr. Garg real quick. Do you think that such a mechanism, when employed in the Indian context, could yield significantly better results, especially considering that the amount or the number of disputes we have is quite large, and expedited procedures in certain areas, if more mandatorily applied, would have more effect here?
So, as mentioned by Kevin and Neeti in our introduction, expedited procedures are usually by default. It is there is a threshold in the institution rules of SIAC, ICC, MCIA, and most other international institutions. And if your dispute is below that threshold, expedited rules would apply. However, Kevin can confirm, I believe if the parties still would not want the expedited rules to be made applicable, they can write to the concerned institution and it could be changed into a regular arbitration. Isn't that, Kevin? That's a possibility, right? So from the point of view of Indian Arbitration Act, we have Section 29B, which provides for fast-track arbitration. Indian domestic institutions like DISE, NPAC, so MCIA I would not consider as a domestic institution. It is more of an international institution in its true sense. So the domestic institution also have very similar provisions, just like SIAC and ICC, where there can be an expedited or a fast-track way to conduct the arbitration. But in my experience, since 29B has been introduced, I don't think many parties have really resorted to fast-track arbitration. They either are a little nervous about the fact that it would be a document-only arbitration, and when a party who gets into a dispute, they would want to say a lot. That's, I think, an Indian way of doing litigation. They want to express themselves to the fullest. They want their witnesses to come. They want to cross-examine the witnesses from the other side. And many of us who practice would agree with me that most of the evidence that is used in our domestic arbitration and even some of our international arbitration is not really relevant. A lot of this could just be done on the basis of documents, but we are habitual of bringing in a lot of evidence. And therefore, I think we, in spite of providing for a fast-track mechanism under the Act, have not been able to make efficient use of that. Now, the question that you had asked, Steve, with respect to MSME and the industry, micro and small medium enterprise segment, I think as far as India is concerned, the MSME Act itself provides for mandatory arbitration. And even if the parties have not put a clause, I mean, this may be slightly different from many other jurisdictions. So, Kevin and Steve, in India, under an MSME arbitration, it is the Act which governs, MSME Act governs, and it, barring the conflicting provisions under the Arbitration Act and MSME Act, it would prevail. So a party unknowingly entering into a contract with an MSME would be forced to an arbitration, which is conducted at a very quick speed. There is a conciliation procedure, and then there is a mandatory arbitration procedure. So as far as MSMEs are concerned, they have been safeguarded by the legislature. But for most others, there is still hope. I hope that parties are mature enough to consider following these expedited and fast-track procedures to reduce the load from the arbitration ecosystem and not go for 3-member and 5-member tribunals when the dispute really is simple and does not require that sort of objectivity. Before I conclude, I just wanted to check with Kevin on this point. Am I audible?
Yes, you are, sir. You are.
Kevin, in Singapore, is there any similar legislature, any act that is in place which provides for mandatory arbitration even if you have not really entered into an arbitration agreement for medium and small enterprises, or is this something which we just have in India?
Yeah. I'll double confirm with Steve. I mean, you have certain statutory adjudication schemes, but we do see arbitrations from these small units, but not mandatorily imposed.
Yeah, Kevin is right, because we don't have any legislation that, let's say, compulsory for small and medium enterprises to go through arbitration. In Singapore, we do have the Small Claims Tribunal, which is part of the state court for certain transactions and of certain value. But we certainly haven't gone down the route of making arbitration compulsory. I think I think one of the reasons could also be that in Singapore, our primary focus right now is international arbitration. So since the local courts are quite efficient in the sense that in terms of the handling of civil litigation in Singapore, so parties who opt not to arbitrate can go to the local courts, domestic parties that is, and they can expect a reasonably quick turnaround for the resolution of their civil disputes through the courts in Singapore.
Right, and Kevin, you mentioned about costs. So both Steve and Kevin, could you shed some light on this aspect for the parties who would be doing international arbitrations in future? Because as one would understand, the amount involved, the sum in dispute would have a direct implication on the costs of arbitration, what the institute would charge. How, in giving a rough estimate, how much difference would it make if it is a sole arbitrator and if it is a 3-member tribunal? Would it make a substantial difference, or would it still be the same because the fee is really linked to the sum in dispute?
I can give you a very quick answer from the arbitrator standpoint. It would be 3 times as much. And so depending how big the dispute is, this makes a real difference. I think more importantly, we know a reasonably famous ICC study now that looks at all of the costs in an arbitration. So that really the fees of the institution and the arbitrators are only about 1/5. It's about 20%. The real costs are the legal fees. And when you have a 3-member tribunal, it's likely that arbitration is going to take a bit longer. And then so that's when the costs may start to balloon a bit. So if you're looking to really save time and costs, in certain cases, a sole arbitrator absolutely is going to be the way to go.
Yes, Kevin is right on that point, because it is quite a simple mathematical exercise of ×3, because the 3 arbitrators will need to be paid. But having said that, costs, the fee scale may be capped or maybe in accordance to a fee structure. However, time is of essence, and that is where we cannot measure the value of time lost. And in theory, if there are 3 arbitrators, then we are talking about the proceedings being substantially slower or significantly slower than it will be decided by a sole arbitrator. So I think whether a sole arbitrator or 3 arbitrator, parties need to really consider this, take this into account. Cost is one thing, and indeed, like what Kevin said earlier on, the Queen Mary University of London report, one of the previous, I cannot remember which year, you can attend this, can look it up on the internet. They actually did a research and have shown that the legal cost, the legal representation cost, it makes up the bulk of the arbitration cost rather than the arbitrators or institutional fees.
Thank you so much. That's actually a very detailed discussion on this, which definitely would make food for a separate webinar discussion on this, certainly. And I think we can build up on that. There's a question which has been received from Mr. Chandrakant Kamdar, and I would request Justice Gupte to please shed some light on it. His question is, what difference would it make when Arbitration Council of India under Section 43 of the 2019 amendment comes in operation, and then what impact would it have on the appointment of arbitrators, sir?
I didn't. There is some disturbance at my end. Couldn't get your question clearly.
I'll certainly repeat it. So Mr. Chandrakant Kamdar is asking that what difference would the Arbitration Council of India make once it kicks in and Section 43 of the 2019 amended act comes into operation with respect to the appointment of arbitrators? So what is likely to be the impact?
No. There is. It's not very clear at all. The last thing got jumbled.
So I think he's just asking as to what will be the impact of be the nature of appointment of arbitrators once the Arbitration Council of India comes in. What will be the effect of it?
No, I'm sorry. There is some disturbance. I'm getting a note on my screen that there's some instability, there's some stability issue at my end.
Let me start answering this up, and possibly if there is better connectivity, you could supplement to that. So I think Yashraj, Arbitration Council of India, the primary goal of Arbitration Council of India is to ensure that the institutions that are in the country are graded to a certain standard. It also provides for Schedule 8, which is the eligibility for empaneling an arbitrator with an institution. So I think the broader objective is to increase the quality and stop the mushrooming of institutions. I don't know if Kevin and Steve are aware, but there are multiple institutions in every small town in the country, and they are just following some international institution rule. They try and cut, copy, paste, and call themselves an institute, empanel arbitrators, and try and get the local industry to follow their rules. So, and there is, I don't want to use a harsh word, but there is, of course, there is no regulation. There is, to say so, there is a cartel of these very, very tiny institutions across the country. So, Arbitration Council of India would make sure that some of these institutions are weeded away. Secondly, it also provides for, under Section 11, the appointment will be done by a designated institute. So, if there are institutes that are to be designated by Arbitration Council of India, if there is an institute within the jurisdiction of that particular High Court where such an appointment request has been made, the High Court by default would send it to that institute, and that institute would make the appointment. So this is increasing the objectivity, bringing more transparency, taking away a little bit of burden from courts for these Section 11 applications. So I think it is a very, very positive step, and if it is done to the light and spirit of the provision and the object for which it has been brought in, it will be a very, very welcome change. I don't know if Honorable Justice Gupte was able to hear me. Sir, I think his screen is frozen.
It doubled the sound, in between, and I'm getting every now and then a caption that there is a disturbance, instability.
So maybe your video might help.
Message. So maybe because it's heavily outside, I don't know what is the problem.
Sir, what you may do is you may stop.
Anyway, you go on, continue.
If you will stop your video, that may increase the bandwidth. Just if you want to try that, that may be useful.
Okay.
Just in case, that may improve the quality. Yash, have I answered the question, or is there any other subset of this question?
I think so. This was the question. This was the answer which Mr. Kamda was looking for, because even his subsequent questions have been largely based around that. So thank you so much for the answer. I just wanted to get some more light thrown about, especially now, continuing with Mr. Garg, in Indian jurisdiction. we've had recent judgments where unilateral appointment for arbitrators has finally been nearly done away with. And I use the word very loosely, nearly done away with in the Indian jurisdiction, at least, through Perkins and then later core electrification. So what do you feel is the future going ahead, and what is the clear legal view that, which stands today in light of both of these judgments?
So Perkins became a very celebrated judgment, and to my mind, what it followed was a judgment of Justice Deepak Mishra and TRF. And TRF also had only interpreted the act, the amendments that were brought in 2015, to say that a unilateral appointment of the sole arbitrator by an interested party is not permissible, because obviously he's an interested party and we are only looking at a sole arbitrator. There is no three-member tribunal. And if that sole arbitrator is also appointed by one of the parties, the element of partiality, the element of being biased, and the credibility of that tribunal is under suspicion. So to say so, TRF and then Perkins made it very, very clear that such an arbitrator would be ineligible. And therefore, as Justice Gupte pointed out, would be a disability under Schedule 7 of the Arbitration Act post-2015 amendment. Therefore, recourse would be in Section 14 and not before the arbitrator, because the arbitrator himself is ineligible. Before I go forward, I would in fact want to know from Kevin and Steve, because to my mind, this is really an Indian debate. I don't think this is a problem anywhere else in the world where parties are able to appoint a sole arbitrator. There's one party that can have the unilateral right to appoint a sole arbitrator. I'm not sure if any other popular jurisdiction has this sort of issue. Would Kevin or Steve confirm? Is this something that is possible in Singapore?
So, or maybe I'll try to start. And in practice, these clauses do exist. Likely the most common clause is it's a three-member tribunal. If the other side doesn't nominate its arbitrator within a certain period of time, the first side's nomination will become the sole arbitrator. So that's a relatively or problematic clause that we see quite often in certain industries. But we really have lots of clauses where you might see, say, one side gets to also appoint the presiding arbitrator, one party gets to appoint all three arbitrators, and then what the institutions have to do, being sensitive and appreciating party autonomy, is have to read the language of the arbitration clause through the prism of the institutional rules, and then come to a result where all parties get to participate in the constitution of the tribunal, while at the same time trying to give effect to the party agreement. But it can be a complicated process for sure.
Okay.
Shashank, in Singapore, for my observation, parties agreeing to arbitrate have always been playing it quite safe in the sense that they will not resort to a rather creative arbitration clause. I know that this is a phenomenon in India. For instance, the central treat is one example of a multi-tier arbitration clause. In fact, whenever I bring up this conversation or discussion about such so-called creative arbitration clauses in Singapore, people will look at me with that kind of look as if I'm proposing something ahead of its time, something from the future. I think the reality is, I think Kevin can also attest to the fact that institutions play a very important role. And so even if the parties will come up with certain creative arbitration clauses allowing, let's say, a multi-tier arbitration clause allowing an appeal of another arbitration, effectively making arbitration as if it is a litigation before state courts. I think the institution would also then look at the rules to see where can the rules actually accommodate this, because it would be quite a travesty if the parties would then use the rules of an institution and turn the rules so-called upside down with their kind of according to their whims and fancies. So that is very much a general observation. Although we don't have the, I don't know of the situation that you have mentioned. I stand corrected, maybe there are, but I only know a case before the High Court in Singapore involving what I call a party's the option to arbitrate at the election of a single party, a one-sided arbitration. I can provide that link, and anyone interested can read it out. But it's a little bit different from the scenario that you have presented, and maybe we can talk about that another time in a different webinar.
Yeah, just so if I would just add on to that, I mean, sometimes you might have a historical clause where neither side wants to have this clause, and the parties might agree to vary. So the institution might invite a variation because neither side really wants to have this sort of unequal appointment power within, say, a three-member tribunal or a sole arbitrator tribunal.
Right, right. So taking the discussion forward, what Yashraj has just asked, in fact, the Supreme Court very recently in the judgment mentioned by Yashraj in Perkins' judgment clarified that the unilateral appointment of a sole arbitrator is impermissible. However, that got little, I won't use the word diluted, but there was a subsequent judgment of the Supreme Court which altered the position to an extent, saying that if you have a unilateral appointment clause and you offer a panel of arbitrators to the other side to choose from, then it would amount to counterbalancing the power to appoint. So that has been made permissible. So there is often a question that what is the way out post Perkins? Is all these clauses that used to be the common clauses in NBFC's agreements, in developer allotee agreements, and many other small industries who were thriving on these unilateral sole arbitrator appointment clauses. I think the only way out is that you create a panel, you offer the other side a choice from that panel, because then you're safeguarded by a subsequent Supreme Court judgment. And also another important aspect from the Act itself is what is the way out if there is a sole arbitrator appointed unilaterally and both parties want to still proceed with it. Because as I mentioned, and Justice Gupte said, that this would be a case of an ineligible arbitrator. Can you remove that ineligibility? That is permissible under the Act. If you look at the explanation of Section 12.5, it says that if you do not want Section 12.5 to apply, you would have, both the parties would have to, after the disputes have arisen, do an agreement, express agreement to do so in writing. So post the disputes have arisen, both parties by an express agreement in writing use the explanation and the proviso of Section 12.5 of Indian Arbitration Act and say that the 12.5 would not apply, and therefore even ineligible arbitrator can proceed with the arbitration. So that is a way out, because that's, I think, a very common concern post Perkins for most parties.
Yeah, unlike the IBA, the three lists, red list, the orange and the green list, and where we have even in the red list waivable and non-waivable provisions.
Right.
In Indian context, we have all these objections waivable. So all these objections, even if fundamental objections under 7, Schedule 7 can be fully waived. Unlike in the IBA case where there are non-waivable and waivable objections.
I think we've lost this connection is a little unstable right now.
So I think your screen is frozen.
I've put off my video.
Yes, sir. Now
what I was suggesting is that unlike the IBA provisions, where we have even in the red list waivable and non-waivable objections. In fact, our 7th schedule and 5th schedule are based on IBA provisions. But unlike these IBA provisions where you have non-waivable list, we don't have such non-waivable list. Everything under the 7th schedule can be waived by a subsequent agreement in writing. That is the Indian position.
That's right.
That's a Very pertinent point, sir. Thank you so much for that. And taking that discussion further, adding on to just a couple of things that I found out rather recently. So US follows the position of Perkins pretty much, where they say that both parties must have an equal say in appointment of an arbitrator, whereas France, on the other hand, follows the idea that even if there is a pre-agreed list, any appointment from there by one party would also work. So it's interesting that jurisdictions across the world have different understandings of the very same thing. And I believe India is at that crucial juncture now where we decide where we want to go, whether we go this direction or in that direction, whether we carve out certain niche and certain types of disputes where a pre-agreed list is allowed. So interesting times ahead, and what Justice Gupte just added definitely would be highly pertinent going ahead. A quick question to all the panelists to get an idea as to what are some of the problems that they have faced specifically in the appointment of a sole arbitrator, and what do they think a sole arbitrator has to be more mindful of, whereas compared to a tribunal of, say, 3? Starting with Professor No.
Okay, I think it's a question for the parties to answer at the outset, because if all that they are thinking of is to save costs, then I think one should be mindful not to be penny wise, pound foolish. I might have said it earlier on, because it doesn't mean that by getting a sole arbitrator is a solution in terms of cost saving, and also whilst a tribunal or 3 arbitrators may be daunting, but that may not necessarily be something disadvantageous to the parties in terms of their situation. And the reality is that appointing a sole arbitrator is always difficult, because in short, when the parties are already in a dispute, it is human nature not to be able to agree on something. So it is a very natural situation, right? So if the clause calls for a sole arbitrator, I would nominate one, the other party will nominate one. It is quite likely that we will disagree with each other's choice in the first instance. So ended up, what is the best way? Ideally, we like to imagine that both of the parties are so level-headed that within in this dispute itself, the only thing they can come to a consensus is a choice of the arbitrator. Then they'll sit down together, look at each other in a gentlemanly and a lady way, and says that, can we just agree for once and agree on one sole arbitrator? I think that can be, I'm not saying that is impossible, just that realistically is that achievable. But again, thankfully, arbitration rules of institutions provide for that mechanism to appoint a sole arbitrator for the parties. So this is just the icing on the cake, because I'm sure the other panelists will share further. For me, I come from the standpoint of, to answer this question, I come from the standpoint of the human nature, and I think that it's very challenging, it's very tough to agree on the sole arbitrator.
Right, Kevin?
Yeah, I'll pick up on some of Steve's points. What you see very commonly is that in the notice, the claimant will propose certain arbitrators. The respondent will not agree to any of them and counter-propose certain candidates for sole arbitrator. And then they're not able to agree, and then the institution will make the appointment. The trick there is this can have the effect of burning the candidate, because the institution called upon to appoint is not going to appoint any of the candidates that have been suggested. One mistake that I see parties make sometimes is being overly prescriptive with the qualifications in the arbitration clause. So it's ensconced in the arbitration clause. I can remember making an appointment in my own capacity where I'm still looking for an arbitrator anywhere in the world that would have met those qualifications. That was how specific and detailed the qualifications were, and there was no person on earth who had those qualifications. One thing that I think all institutions do is they look at proposals. So if the parties are not able to agree, the institutions will always try to give effect to proposals. So one side might say that the sole arbitrator needs to have 20 years experience and experience in major projects. The other side might say that this arbitrator also needs to be qualified in these jurisdictions. And if we can find a candidate that meets the proposals of both sides, that can be a good way to do it. I think for a sole arbitrator, one thing you have to balance is marshaling the proceedings against due process. I think sole arbitrators in administered cases are helped quite a bit, because it can be the loneliest place in the world. you don't have the other tribunal members to deliberate with. But in an administered arbitration, particularly at SIC, when we have a scrutiny process where we review the awards, so the sole arbitrator has been dealing with the case every day for 12 months, to have a second pair of eyes and to have the institution be able to review and then approve the award can be quite helpful. I guess what a sole arbitrator has to overall be mindful is cultural considerations. One thing that a 3-member tribunal is very good at doing is giving effect to cultural considerations from both sides. So an arbitrator, hopefully if the institution is making the appointment, will appoint an arbitrator that is sensitive to the legal traditions and cultural traditions of both sides. Increasingly, what we're seeing and SIC is happy to do as an institution is parties are getting a bit more sophisticated. If they can't come to an agreement, we are seeing a slight uptick in use of a list procedure or a striker and rank. So the institution will furnish a list to the parties. They will send it back separately to us with a ranked order of these sole arbitrators. So that can be a way to give the parties a voice in the process, even when they can't come to an agreement on a sole arbitrator.
Yes. Yeah, in fact, I think there is any institution that has this striking out a list system. Each party will provide a list of 5 names that they would like to be considered for potential appointment as sole arbitrator. Then they will compare these 2 lists to see what is the last name on the list, if any. Then we'll make the appointment based on this striking off system, the list system.
Yeah, I think I've already answered that question when I was addressing the audience before. But just to carry forward the point that was raised on the aspect of qualifications. In Indian scenario, if there are several qualifications or there are prescriptions to what sort of an arbitrator should be appointed, I've seen the court would, although keep in mind, and Justice Gupte may have his view on this, court would keep in mind what has been agreed in the clause. However, court would finally take a call on what's best suited for the parties. So if it is a reasonable qualification, if it says it has to be a former judge of a high court or something which is as reasonable as that, then that would certainly be accounted for. But if there are unreasonable qualifications, which would, as Kevin mentioned, makes it almost impossible to find such a such a gentleman or a lady across the globe, then I'm sure the high courts in India or the Supreme Court, as the case may be, would not really be deterred by what the clause prescribes and would go ahead and use their own wisdom and appoint a suitable arbitrator. Justice Gupte, so would you agree to that?
Yes. As a judge,
say your bandwidth is low.
That third line of authorities, which, as I said, is a halfway house, where as far as possible we must compute them. See, as a judge, I would find favor with this third approach, the halfway house, which I discussed in the opening address. Namely, we must, as far as possible, give deference to party autonomy and what the parties have proposed in terms of the manner of appointment or in terms of qualifications. So as far as possible, we must do that. But in an appropriate case, if we find that either this is too cumbersome or it cannot be conveniently applied, or as Mr. Nash has suggested, that to find go around this and appoint an arbitrator. After all, the very point of therefore the court is asked to appoint an arbitrator and resolve disputes through the mechanism of arbitration. That appoint an arbitrator and not require the institution or party to follow the mandate of the arbitration agreement.
Thank you, sir.
and appoint an arbitrator which fits the bill.
Yes, you want to continue?
That is how I.
Yes, sir.
That's quite a point, sir. Thank you so much. Just moving the discussion further forward, and we'll just end with a couple of discursive questions. One being, particularly with respect to the situation in India, a little specific here. So after the Perkins dictum, what has happened is, because there's not really a lack of, there is a lack of clarity on whether it's a prospective application or it's a retrospective one. So as it stands, the mandate of all the arbitrators is likely to be challenged, even those that had started from 23 October 2015 onwards. Now, would that be a huge problem going ahead, or how do the courts and Mr. Garg as a counsel, how do you see this going ahead, and how do you think the courts and the councils and the parties should deal with it? Because all the arbitrators are likely to have their mandate challenged now going ahead.
Okay, so unfortunately for you, Yashraj, I have a very biased view. I have been writing against the unilateral appointment of a sole arbitrator even before Perkins had come. And if you look at Perkins, the entire discussion started with a judgment called D.K. Gupta versus Renu Munjal, where I was counsel for the losing side, which had in fact allowed a unilateral appointment of the sole arbitrator, and therefore it was then rectified by Supreme Court after Perkins had come. My view is the retrospective application that you have mentioned, that arises from the Delhi High Court's recent judgment in Moderator cable, where the Delhi High Court single judge has said that it would be a retrospective application since the judgment is only clarifying the 2015 amendment. It is not really a new law. So therefore, it should be applicable right from the amendment itself. Now, the problem is certainly huge, and as I said, that I have a biased view, and I'm all right with parties who have made that appointment should suffer. But the problem is that not only in the initial stage, a challenge can be brought even when it is at the stage of final argument. A challenge can be brought even if the award is pending. A challenge can be brought even at the stage of execution. If the arbitrator so appointed was ineligible, a challenge can be brought even till the stage of execution. So that this could mean that the process that was commenced, entire arbitration has gotten over, 2 years have been spent, a lot of money has been spent, can go back to zero because the arbitrator so appointed has been declared ineligible, or so to say not declared but clarified by Perkins judgment that he is ineligible. So of course it opens Pandora's box. There may be several such disqualification or removal applications. In fact, Delhi High Court in section 14 has terminated a series of mandates of arbitrators who were ineligible. And Justice Jyoti Singh in that judgment which made it retrospective has clarified that if you had not made a challenge under section 12 during the pendency of the arbitration, that would not really be a disadvantage for a party to bring about a challenge under section 14. So yes, it is a very, very difficult situation for parties where unilateral appointment was made and arbitrators were holding proceedings and parties may have awards in their favors. So we will have to see till this judgment is altered with, this is the position as far as Delhi is concerned, and I'm not aware if this has been followed anywhere else in the country. I'm not aware if Bombay High Court has taken a view or not, but this is the position with respect to Delhi High Court.
Thank you so much, sir. I know that your views definitely are pretty strong in this regard, but definitely that's a pertinent point. To Justice Gupte, how do you see the courts dealing?
I would like to add a bit here.
Yes, sir. Absolutely. I was coming to you.
I'll just stop my video because if you see section 14, it says that the mandate shall terminate if the arbitrator becomes de jure unable to perform. So moment we have a provision like 12.5 read with the 7th schedule, the very introduction of that law makes ineligible, de jure unable to perform his functions as an arbitrator. So therefore, even by introduction of this law, he may attract disability under 14(1) read with section 12(5).
I think, sir, your response would inspire a lot of practitioners in Bombay to file such applications in near future. You may be adjudicating some of these applications in near future.
Yeah, therefore, I had made it though. At the very outset, I had made it clear that in an ongoing debate, I may not be answering, but this is a matter of course, academic interest.
That's right.
So that appears to be one way to look at
That's
it.
right.
Absolutely, sir. Thank you so much, sir. I think so we are reaching towards the end of the webinar. So just a question, starting with Justice Gupte's view on this. It's come from one of the panelists and something which I also had in mind. Going ahead, I think so all the arbitral institutions and the entire arbitration fraternity is trying to increase diversity in arbitration sphere, especially in terms of appointment of arbitrators and also ensuring general diversity amongst the institutions. So how do you think the courts can play a role? Then Professor No can probably let us know what the institution, and Kevin can also let us know what the institutions can play a role. And we'll end with Mr. Garg's comments on how the councils, etc., can also play a role in increasing diversity amongst the arbitrators.
Yes, I'll try to be very short here, be very brief. I think it also takes two hands to clap. Those who, in terms of gender diversity, for instance, I think most institutions are very open-minded about it, and they are very welcoming different demographic of practitioners who want to be considered for potential appointment as arbitrators. So I don't think there is such thing as any discrimination or a preference for certain gender. In my own past experience in looking for an arbitrator, the first thing that will come to my mind is not about the gender. It's about finding an arbitrator, and we would consider both male and female arbitrators for that matter. So I don't think there is any discrimination, but it really takes all to come together and say that for those in particular who wants to be considered for appointment as arbitrators to perhaps attend more events and discourse and networking events and sessions to be able to be in touch or connected to the industry. I think that's one way, the very first important steps.
Thank you, Professor. Maybe Kevin, you can just add on to it as to how an institution goes about ensuring that they do their bit to promote diversity.
Sure. To a certain degree, institutions are the thought leaders in this area, because if you look at most institutional statistics, the institutions are doing very well with diverse appointments. It's taking a bit of time for the co-arbitrator nominations and the party nominations to be able to catch up. One of the most satisfying things that I've seen is when we appoint a first-time arbitrator, and then you see that arbitrator starting to get more traction in the community because the community realizes how talented this person is. So I think the institutions are really giving arbitrators a chance to show how good they are. One thing when you're looking at diversity from our standpoint, and I'll focus a bit on India here, what we want to do is we want our arbitrators to match our diverse user base. So we've had, in SIC arbitrations, we've had our parties from more than 100 jurisdictions in the past 5 years. Surely we cannot, as the old joke goes, just be appointing the same 10 arbitrators from Europe. We have to make sure the appointment of our arbitrators match our user base. In that regard, in 2019, we almost had 500 parties from India, just an extraordinary amount of Indian users choosing SIC. So one thing that we're very consciously trying to develop is, and in particular, the young generation of Indian arbitrators. So you see the sophisticated, precocious counsel who may not have sat yet as an arbitrator. We watch their performance as counsel in SIC arbitrations and then find an appropriate case to give that person an opportunity as an arbitrator. I think the important point here is that we are still appointing the best in the world. And these people just happen to have diverse characteristics as well. You don't start with diverse characteristics first. You start with best in the world, wherever they are in the world. And if they happen to have diverse characteristics, even better.
Quality is the name of the game, as I understand, Kevin. Absolutely.
Sure.
Right. Mr. Garg, please, your points, viewers on this. I think you'll have to unmute yourself, sir.
I think it's a very valid point. The appointment must be based on the caliber and capability of the person, and diversity is an additional factor to be considered. But as Kevin said, it cannot be just for the sake of diversity. One can forego the merit that is required in appointment of an arbitrator. Now, looking at the Indian domestic scenario, I can talk about Delhi and Mumbai. Both high courts have been increasingly appointing young professionals, partners of law firms, advocates, even professionals like chartered accountants and engineers in disputes where their expertise is required. And the old saying in India, similar to what Kevin said about 10 arbitrators from Europe, was judges appointing judges. I think that has already almost been done away with. Yes, judges are being appointed. Parties prefer judges in most disputes, but I don't think that really is a huge consideration now. The Section 11 judges, at least in Delhi and Bombay High Court, have been increasingly looking at a varied pool of professionals while making these appointments. So diversity under Section 11 has certainly come in. And then the remaining bit is on parties. While they have to choose and they have to appoint, they should also look beyond the popular judges. They should also look at other professionals and experts in the field. So.
If I may just add something very quickly, looking at the situation in India involving Indian law students coming up with a lot of very innovative initiatives and solutions. For example, I've seen so many students who are still in university, but initiating activities such as publications, seminars, and so forth. I think that is a good start as well, because they are allowing themselves to be plugged into the system and to be part of the community even before they enter the industry. That's very important. And I also see a vast gender diversity. So it's not just necessarily restricted to certain demographic of the society. So in short, I think my advice is keep it up. Good job.
That's indeed really encouraging, sir. To Justice Gupte, just the same question, but what role do you think the courts can have in making sure that this that they do their bit in increasing this diversity?
See, my experience has been that in some specified subjects, like say, for example, construction contracts or insurance claims where there has to be assessment, on these particular subjects, I have seen many times professional technical arbitrators do well. But whenever there is evidence to be led, there is a trial to be conducted, then invariably it is the judges who fit the bill. I mean, some ex-judges, or even for that matter, we many times appoint young counsel practicing in our courts as arbitrators, in of course these ad hoc arbitrators, and we have found them to be eminently suited for the job and doing excellent work. But these two particular areas, I would say, I would as a judge leave to, I mean, I would favor a professional, technical professional. That has been my experience.
Thank you so much, sir, for sharing that experience. And in fact, that's a very unique point of view and a very encouraging point of view for all those people who are trying to, make their mark in the industry. I would just put everybody on the spot, maybe 30 seconds, because we are already out of time. So just 30 seconds from everyone giving their 2 bits on definitely the practice of sole arbitrator is here to stay. I mean, it will continue to, because we are in Asia, a 3-member tribunal is not always the most effective. But where do you see sole arbitrator appointments going ahead in the future? We'll start with Justice Gupte.
I think it will be soon a norm of the day. That is my view. Yes.
Thank you, sir. Professor No.
Well, I think it has been around for a long time. It's a choice of the parties, and depending on the disputes and the circumstances or the rules of the arbitration. So I think a sole arbitrator will stay. But we cannot deny the fact that there'll be people who agree or disagree with the idea. So to that, I would just say, dogs may bark, but the caravan passes.
Absolutely, Kevin.
Yeah, I agree completely. It's very difficult to come up with a general rule for every case. So there's certain cases where a sole arbitrator is going to be very appropriate, certain cases where a 3-member tribunal is appropriate, certain cases where maybe a tiered mechanism, we're seeing more of that, where you're going to have pre-arbitration steps. So to a certain degree, and going back to the fundamentals of arbitration, we want to be flexible and give effect to the agreement of the parties. So whether that be sole, 3, 5, 2, with an umpire, we can accommodate them all at SIC.
Yeah. I think the takeaway for parties appointing an arbitrator is, while drafting the clause, be very sure of what a dispute is likely out of this contract. Because in my experience, it is very difficult to put in a clause for 3 arbitrators and then agree for a sole arbitrator post the dispute has arisen, and even vice versa. Yes, courts sometimes intervene and see that if a clause says 3 arbitrators, but the dispute is very, very small, try and convince the parties to go for a sole arbitrator. But in my experience, it is very, very unlikely because of the predictability that the party envisages with a 3-member tribunal. It is difficult for them to then get convinced to appoint a sole arbitrator. So the long and short is, while drafting the clause, be aware of what sort of a dispute and what could be the length and breadth of the dispute, what quantum could you reach with that dispute, and make a choice, make an informed choice, and don't follow a simple template. Don't do cost cutting if you really think it's a complicated, complex dispute that may arise out of a contract, and you would rather want a judicial expert, a subject matter expert. So you would want a panel of 3 or 5 where these other experts can also be accommodated. So those points are to be considered. And yes, I think if that is kept in mind, we would have many sole arbitrators and many 3-member tribunals appointed.
Thank you so much, dear panelists and Honorable Mr. Justice Gupte. And there you have it, audience. Brilliant, insightful, informative discussion, giving you all the perspectives from around the world, touching upon sole arbitrator appointments in general, and also unilateral appointments in India. And as far as I'm concerned, as long as we have mentors in the field like Justice Gupte, Professor Naw, Kevin, and Mr. Garg, I know that there is a place for all the young lawyers and all those young interested arbitration practitioners coming up, that the future of arbitration is in safe hands, definitely. So I want to thank again Honorable Mr. Justice Gupte for taking out time today from, I know, definitely his busy schedule going ahead. Thank you so much, sir, for blessing us with your presence and your words of wisdom.
Pleasure.
Much Professor Naw, Kevin, and Mr. Garg for coming out with this idea, spearheading the whole discussion and giving us lots of food to think about and lots going ahead. And I'm sure all the panelists would have a lot of questions for you, so they can send it across to us and we'll be happy to share it with you. So to all the participants, thank you for tuning in today. I hope that this served a good informative purpose and an educational purpose for you. I am also thankful to our supporting partners in this endeavor, Mumbai Center for International Arbitration, Ms. Sachdeva, Indian Arbitration Forum, and the Lawlex organization. On behalf of the Center for Arbitration and Research, thank you once again. Have a great weekend.
Thank you. Thank you.